Excuse me?
Why is it effective at midnight?
Because we had this emergency request, which we made to them. Why Erica.
These cases are real. The reactions are real, and every day. We cover a new moment where the truth finally comes out in court. So if you don't want to miss the next case, go ahead and subscribe now.
Good afternoon, Your Honor. Steve Etherly on behalf of Plaintiff Fixing Housing 401k Plan.
Donna Tope on behalf of Erica Ward and Aaron Ward tenants.
Your Honor, I believe my client, Griffin Hawk, I think I see him right now. He's on Zoom. He couldn't attend today.
All right. Yes, what is your name, sir?
Me? Griffin Hawk.
Yes, sir. Say again.
Griffin Hawk.
Yeah. Okay. All right.
Your Honor, we're here for our fourth pretrial hearing. If you recall from the last hearing, you adjourned to give plaintiffs time to seek alternative counsel.
Right.
It appears that they used that time to file a dispositive motion and an omnibus motion for repairs and Ms. Tope's motion for withdrawal 2 days before this hearing, which I received a copy at close of business on Wednesday, which forced landlord to file its own MSD, which was filed with the court this morning. So it appears it is further delay by tenants, and it's another month with my client not receiving any rent payment for his property.
So I can just tell you what I agree with everything that you said. I can just say from the court's perspective, because of the way that my docket is, I did not see these various motions actually until late yesterday, but I have a life. So it was really this morning that I saw that, and then I saw your motion came in.
Yes.
And I have that.
Your Honor, I brought a hard copy if you needed one.
Of your motion?
Yes, landlord's MSD. You got it? Okay.
I got it.
Good.
Okay. So, Ms. Tope.
Yes. I filed judge's copies for you that had the tabs attached for the 3 motions for repairs, one of which is an emergency, and that's why things were delayed in getting the motions to you. I also filed a motion for my withdrawal, and I gave the underlying theory that the tenants have agreed with, and that is ready for your signing. I attached an order at the back of that, and then I filed, and it's effective midnight today because we had the emergency request for repairs that was made a week ago. And we filed a motion for dismissal with prejudice and damages based on retaliatory eviction.
See anything wrong with all of that?
Your Honor, I know you have expressed several times your not order and not opinion, but your advice that my representation of the wards somehow is ethically compromised. But I have tried each time that I have appeared before you and you have expressed your concerns, I have tried to give you the underlying basis for why I represent them and how I have conducted myself in that representation, including today. And that is in my motion, the underlying legal basis, and it's on Exhibit 1 at page 5, and it says that a bank account or other account held by a third party generally established in the name of the tenant into which whole or partial rent deposits are made to show that the tenant was ready, willing, and able to pay the rent, but is withholding the rent until a certain problem is fixed. And that is exactly what Erica Ward did. The money was not held in a legal IOLTA account.
Which might be part of the problem.
And you say might.
You can't do both.
Okay.
Counsel.
Okay. I agree. My clients and the plaintiff do not need to spend any more time with your concern with how the money was held. I have filed a withdrawal. They have agreed. They are perfectly able, competent, and know everything about this case and are wanting to exert their right to represent themselves. And that's what this motion says. So they signed it. It's a stipulation, and I've signed it, and I have the order ready for you.
So are they really? So if that's the case, then why is this effective at midnight?
Excuse me?
Why is it effective at midnight?
Because we had this emergency request, which we made to them. Why Erica, made to them to fix electrical fixtures in the residence that are used for auxiliary heating, which in this temperature weather is essential for the safety of the residents, and the outdoor security lights, which have gone out, and with the unsafe conditions out in the driveway and the walkways.
This is where things start getting legally tricky. The tenant's side is arguing that they withheld rent because essential repairs weren't made, specifically electrical outlets used for auxiliary heating and security lighting. In many jurisdictions, tenants can sometimes withhold rent if a landlord fails to fix critical safety issues. But there's a catch. It usually has to follow very strict legal procedures. Money often needs to be held in a proper escrow or trust account, and notice requirements must be followed carefully. And here's the problem the judge is hinting at. If the funds weren't placed in the proper legal account, the court may view that as a violation of the rules. On top of that, the emergency motion timing is raising eyebrows. Filing something labeled an emergency just days before a hearing can sometimes look strategic rather than urgent. So now the judge is weighing credibility, timing, and legal procedure all at once. What do you think? Are these genuine safety concerns, or is the court starting to suspect procedural gamesmanship?
Those are essential. And the plaintiff refused to reply, refused to make the repairs. And so that, knowing that we had this hearing today, that is one of the motions, motion number 3, which is requesting permission for the defendants to make essential minor or electrical repair, which the plaintiff has refused to address, and to deduct the cost from the rent on January 1st.
You can't have it both ways.
How
And
do
you can't have it both ways.
then I would ask that you recognize that the wards made that request of the plaintiff, take me out of the picture, and they did not reply. And if you would like them to stand up here and say exactly what we say,
Are they going to be able, folks, are you going to be able to give me the legal arguments that are necessary?
Legal arguments? I
Yeah.
just take the facts.
Okay, but you understand that I would be taking facts as I found them, applying a legal standard to that and making a decision. You understand that? And are you prepared to make the legal arguments?
I guess I don't understand that.
I understand your question. I think we're in tough.
So what's the answer?
Yes, we are. We'll do the best we can. You know, we have a business that doesn't make any money. The attorney fees would be.
Sarah, I get it, but I also can't.
It's a tough situation. I
Pardon?
understand your question. So yes, we'll do the best we can. And it is what it is.
Let me ask this. The conditions that are complained of, how long have those existed?
So,
the electrical outlets.
the electrical outlets on the outside I've only noticed as of this winter. They were working fine.
So how does this become an emergency motion?
Because the water freezes and then
No, I get that happens in cold weather. I understand
I
that.
have to use water heaters.
Okay, but I guess maybe I'll ask this. You're asking me to address this as an emergency motion where the court has only had an adequate opportunity to view it. Plaintiff has only had as short time, if any, to look at it. And I have to first determine that it's an emergency. And I'm having an issue with that. If you'd known the conditions existed, this motion shouldn't have been filed on Wednesday.
The reply was made. The request to repair the electrical was made when? A week ago.
Yeah,
But that's not the issue.
I didn't realize it wasn't working. I claim this.
Okay. The weather makes it an emergency. The receptacles that just were noticed that aren't working are used for auxiliary heat in the residence. The security lights just stopped working. The plaintiff was requested to make the repairs and respond, and they did not.
Folks, are you going to be able to handle this from a legal standpoint?
Your Honor will.
You realize, so hang on a second. You realize that plaintiff has filed a motion for summary disposition. That's going to need to be answered and then argued before this court. Have either of you ever argued a motion for or a motion for summary disposition?
Oh, yeah.
How are you intending on doing that then?
I just saw it on the way here, so I didn't even review it yet.
It's the last one.
Oh, and I know where it is.
Okay. I'm not worried. I was trying to be helpful.
Let me just tell you, I will hear all of these motions at some point. There's not a doubt I'll do that. But I don't and can't justify that motion is an emergency motion that
Your call.
plaintiff hasn't had an opportunity to view and respond to. But then you're requesting that I take some action as against plaintiff. And I don't deem this to be an emergency. I think I won't go as far as plaintiff counsel that it's a delay, but it's just, it can't be an emergency at this point. Because this condition, to the extent it does, must have existed. And it didn't just get cold Tuesday.
No, it didn't. But the need for auxiliary heat became apparent with this frigid weather.
Because of the water.
Hmm?
Because of the freezing of the water.
No. Because the electrical outlet in the residence became known to be faulty a week and a half ago.
I don't have any way to check that.
I know.
Any way to.
Well, I
I'm
did
not
include
not having them respond to that. Counsel, at best, when you have motions such as this, even though these are summary proceedings, you have to give them the time under the court rule.
We requested the repair a week and a half ago, and I included those emails and their non-response in the motion. And if you can't act on it now, I totally understand your ruling because it wasn't timely, but it was as timely as it could be given the fact that we gave them 4 days to reply to making the repair themselves or telling the tenant to make the repair, and we got no reply. So that's why the motion was filed on Wednesday.
I don't care.
Okay.
File the motion whenever you want. I
Yeah.
just don't see a basis to hear. I don't see a reason to hear it on an emergency basis.
Got it. We had this hearing already scheduled, so I thought it would be in judicial efficiency to present it to you now rather than.
There is nothing about this that is leading to judicial efficiency.
Well, that is a motive. That is one of my motives. It's judicial efficiency. I know you don't agree, but.
Well, no, I just don't need your help.
Because I can do that on my own. Counsel.
She filed a dispositive motion 2 days before and is now claiming that it's an emergency. Your Honor, I would add that if you're going to when you're addressing the pending motions, to rule on our motion first because it moots out their motions. And also when they're talking about emergency, my client is also being prejudiced because he's not getting any money from the property and he's defaulting on his own financial obligations. Mr. Hawk can provide more information on that, but he's suffering his prejudice while they're delaying for months. I mean, Your Honor, we're going on almost half a year where they're not paying rent. So, Your Honor, I would respectfully ask you to rule on our motion.
And let's just be clear in terms of the not paying the rent. I permitted plaintiff to keep a certain portion that he had been paid to him, whether rightfully or wrongfully it was deducted, but I permitted him to keep that. And I have in escrow the ordered amount of the 4125, which I ordered in November, and December's 5,500 has been placed in escrow.
I should have been more clear. Receipt of money, Your Honor. I would.
No, I know what you meant, but I just wanted the record to be clear.
Yes.
As to.
I would like to make a point though on the partial payment. My client's Chase bank account, because there was no activity with them not paying rent, it was, I think, deactivated, so he can't even cash this check. They're saying that he cashed the check. He can't cash that check.
Well, it was withdrawn. The check was cashed and the money was withdrawn. Finally, like 3 days ago.
Yeah. Why don't we have him? Why don't we have? Yeah, go ahead, sir.
Can I comment?
Yeah, go ahead.
Okay, thank you. Sorry. So because of the non-payment of rent, we've experienced loan defaults, which was intentional. My account was overdrawn, and it was actually canceled by the bank. And it's difficult to open these accounts based off of the way that that I own the property. It's not just a normal business account. It's a self-directed real estate 401k bank account. So not many banks will do that. So not only has this caused us financial hardships, it's caused us to lose that account. Now we were able to open another account, but that still doesn't catch us up on the obligations of the tenant to pay us rent and use the property. And
I know, I get that part. Everybody, in case anybody isn't aware, I understand the ultimate conclusion that everybody wants to get to from their respective sides. What I'm trying to figure out is the funds that were paid for, I guess it would have been, it may have been paid in October, but not applied for that month because of first in whatever. It was like 3,300 or something.
Yeah, and
508.
it was
So my
paid
question
for November 1st rent. The check was sent for November 1st rent.
We talked about
No, I am not. Yes, I am not getting into what month that will apply to because I'm not getting it. I'm not going down that rabbit hole. Sir, are those funds, that 3,500, whatever, is it the case you cannot access those monies?
No, I was able to convince Chase to open a new account and deposit that check.
Gotcha. No, it's okay. I just, you knew it. The facts you relayed to me were the facts at a certain point. He's done something else, and so now it's open. Okay, all right. Okay, so
Your Honor,
go ahead, sir.
I was never contacted about anything related to electrical outlets or any emergency. I don't understand why they are saying that.
Your Honor, I received an email. I received an email about a repair. I didn't even know Ms. Tope was still representing the tenants. So I think we're past the emergency motion, alleged emergency motion.
Yeah. So here's what I'm going to do to try to make this clear. I'm going to grant the motion to withdraw. I am not going to sign the order that you've indicated. You will prepare an order that it is effective now.
Okay. We can just write it in.
You can do whatever you want to do. I just need something to sign that indicates that you are
Effective immediately.
immediately.
Yeah, and I'll sit down.
You folks are not in a position to argue anything regarding this right now, are you? Well, one saying yes, one saying no. What
Oh, I'm just nodding and listening to you. I'm just
so what I'm gonna do is this. I'm gonna set all the motions for hearing. And the quickest that I can get it done where I can look at everything and give you time to, here it is, January 6th at 11 a.m. So all the currently filed motions, with the exception of the motion, except for the motion to withdraw, which I have ruled on second time, quite frankly, will be heard on that day.
Okay.
Counsel, with respect to the motions that have been filed by the defendants in this case, how long will it take you to respond to that those motions?
For me?
For you.
I mean, I can.
Well, let me just do it this way, because it's going to be, I'm going to.
They're non-dispositive motions, so I think under the court rules, I have.
Well, except for the fact that this is a summary proceeding, so the rules kind of
Okay. Yes.
But I don't want to put anybody behind. I'm not trying to do that. I want to give everybody time to at least get something to me and respond to what's there. Can I get a response? Can you file a response by the 30th?
I will get it done. Yeah.
All right. So now, folks, you've got to respond to their motion, the plaintiff's motion for summary disposition. Are you going to be able to respond by the 30th?
Are you talking about the thing I just saw today?
Yeah. Well, I'm assuming the thing you saw today was this.
It is.
Okay, yeah. I mean, I briefly.
Yes, so yes.
I mean, we just got it at 12:30. And I forwarded it to them by email.
So you can respond by the 30th.
Yes.
All right. I do not need replies to any responses. I will give you time to argue what you need to argue before me. I think I can process it. I just don't need that. I'm also going to direct, at least at this point, that there are to be no other motions filed between now and the time of that hearing. All right.
I appreciate that, Your Honor. Thank you.
I have a question.
Sure.
And Mr. Etherly has stated that their motion that was received at 12:30 today is dispositive and is essential and needs to be heard. However, the motion to dismiss with prejudice that is filed on behalf of the defendants should be heard first before his motion for summary disposition. That's just a comment because this was filed on Wednesday.
Can I just tell you this? I gave.
You don't care what I say.
No, just think about this for a moment. I understand what counsel was indicating to me when he's indicating to me that he wanted that one heard. But his basis for doing that was his belief, and I didn't respond because I don't know, is that would be dispositive of all of the issues, and we would maybe have to deal with that. I get what he was telling me, but he didn't harp the point home and tell me, Judge, you got to hear this one first. I mean, I set everything for one day.
Yeah.
So I really don't need to be told that that motion needs to be addressed. Here's how it's gonna work. I've been doing this for a minute up here.
Yeah,
I'm gonna hear
27 or
them
something, yeah.
the way I'm gonna hear them. And even if I hear them what seems to be out of order, I can figure that out as to how to rule on these.
Right.
Everybody okay with that?
No, that's
I mean,
perfect. My only comment was intended to be able to address what Mr. Etherly had said, not any, decisions or anything that you would be making. Here is the order for you to sign.
Has council seen it?
I have not seen it.
Oh, you got a copy of that, or that?
Well, but you changed it. So customarily, you then show it to opposing counsels for, see if he has any objection. That's the way it works.
No objection, Your Honor.
Oh.
Thank you.
I was afraid to ask. Any other questions, comments?
Want to confirm January 6th at 11:30 a.m., Your Honor?
Yes, at 11 a.m. Okay. Responses to all motions are due by close of business on 30th. All right. If I could, and because I'll be trying to take a little bit of time off with the family, if you could get my coordinator's email address so that the judge's copy comes email so that it can get to me wherever I happen to be. All right. We will make sure to provide that to you.
Yes.
All right. Folks, do you have any questions?
Sorry,
No? All right. I guess in fairness, you have any other questions?
I have no other questions.
All right. And my last point will be this. I am not ignoring the financial statements that are made by the plaintiff. Although at this time I'm not prepared to release any of the escrow funds that are held, the court is reserving the right to change that or modify that and may release some of that as it's paid. There is 9,000, looks like 9825 that is currently in escrow. 9625 in escrow, and that when we reconvene on the 6th, an additional 5,500 should be
Thank you.
in escrow. All right. Thank you, folks.
Thank you, Your Honor.
By the end of this hearing, the judge makes one thing very clear. The court isn't going to rush into decisions without fully reviewing everything. The attorney for the tenants is officially allowed to withdraw immediately, which means the tenants will now have to represent themselves unless they find new counsel before the next hearing. That alone dramatically changes the dynamic of the case, because arguing complex motions like summary disposition without legal representation can be extremely difficult. The judge also schedules a full hearing for all motions on January 6th and confirms that thousands of dollars in rent are currently sitting in escrow while the dispute plays out. That means neither side is getting exactly what they want, at least not yet. The landlord is still waiting for resolution on unpaid rent, and the tenants still have to prove their claims about repairs and retaliation. Cases like this show just how complicated landlord-tenant law can become when repairs, rent withholding, and legal procedure collide. If you found this courtroom battle as intense and fascinating as we did, make sure to hit that like button, share your thoughts in the comments about who you think has the stronger case, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal drama.